till the creditor started moving with due consent, then you suddenly filed it after a year. And then for 10 years you did nothing with it, and suddenly then the scheme gets sanctioned. Now, if in this time frame, IBC proceedings are permitted to be derailed to say that, look, my scheme stands sanctioned, the LPA has stayed the order recalling it, so it's been revived, and thus no Section 7 should go on in the matter. Now, since then, my lords, plans have been invited and are now under consideration before the COC. Now, in this kind of a situation, my lord, your lordships were kind enough on the first day, because RP had been in control since 2024, my lords, and then briefly because of the order of the NCLAT was divested of the control which your lordships restored with the order that your lordships passed, issuing notice in the matter. Now, my lords, this order of NCLT was this order of NCLT was set aside by NCLAT, and it said that the Section 7 petition will be kept in abeyance until the LPA is decided, and in the meantime the NCLT order, the 27/2024 order, is set aside. Now, my lords, that is the order that we came before your lordships against by way of an appeal, because A, that proceeding cannot in any way stop the IBC from proceeding with the matter, one. Secondly, my lords, the facts of the case are telling and important in this matter, that can a party which is meant to pay amounts in 2000 takes a loan, in 2008 has a scheme of arrangement, doesn't pay, then suddenly in 2019, after the creditors have withdrawn consent, gets a scheme sanction which is recalled and stayed in an LPA, come forward and say that the IBC will not go on, which in any case has a non-obstante clause, and your lordship's judgments have said is a completely independent proceedings. My lords, that is the conspectus of the matter, and even as per that belated sanctioning order, the ROC filing did not take place. So there was no valid scheme as required, even if that order is taken to be a correct order, was not done. And your belated filing in 2023 will not make a difference at all that you did with the ROC. In any case, my lords, they now come and say, subject to verification, that apparently 37 or 38% of the creditors come and say that apparently 37-38% creditors have again given their consent. I mean, that still doesn't meet the threshold of 3/4 under 391, which is not there. Secondly, the NCLT even at that stage said, when it passed the order in 2024, where is the approval of the ROC? There was no approval. What they now produce here in the proceedings before your lordships is a 2023 filing. That is the broad conspectus in which I will.
What a glorious ride. The legacy lives on. Yamaha XSR. Build your own way.
And the law on the point.
Let us just look at the stay order in the LPA ones.
Yes, sir.
Page 150.
Yes. Learned senior counsel for the appellant inter alia contends that while passing the order dated 23/7/19, a specified finding has been given in para 5 at page 445 of the paper book that during the pendency of the appeal, respondent number 7 took over the debt of respondent number 1, 3 and 6. Vede order dated so-and-so, respondent 1, 3 and 6 were discharged. Thereafter, respondent number 7 was treated as a party and debt of respondent was liquidated. Thus, there was no procedural lapse in recording the fact that respondent 7 has taken over the debt of respondent 1, 3 and 6. It has further been submitted the debt of 1, 3 and 6 comes to more than 70% of the debt of respondent number 5 is added. It would come to more than 75%. Hence, there is no procedural lapse in recording the above finding.
You are respondent number 7.
We are respondent number 2.
Who is respondent number 7 there?
Someone who's taken over the debt of some of the other creditors.
And that person consented to this.
Yeah.
There's no mention as to,
But he says the same.
there's only appearance for the counsel for the appellant. There's no one appearing for the respondents at all.
Yes, madam. This
was an ex parte.
This is the one. This was an ex parte order.
Which is that?
Order 2822 is recalling. No, we need to understand this array of parties in the LPO. Do we have the
Right.
cross title of the LPA?
What? No?
You took over the debt.
One of the creditors.
Which one was it and
I
what was the
don't know.
percentage?
IDBI, I think, my lords, transferred the loan to what is called the Stressed Asset Stabilization Fund. And from the Stressed Asset Stabilization Fund, then it comes to us. My lords, I don't
But
know whether
IDBI must be a party in the LPA also.
Because I have to confess, I don't think the LPA with the memo of parties
It's not there.
is I have to
We
confess.
need to at least understand who is.
Because
who
I
here.
can do one thing. I can, whatever your lordship says, I can either
For the order,
yes.
for the
Because I
completeness
can
of
do,
the order, at least we need to know who is.
I can do one thing subject to what your lordship says. Either I can continue, or I can come back a week later with at least this order that your lordships have pointed out on who took how much of the debt and what.
This seems to indicate that the counsel for the appellant projected it as if.
Yes,
the
yes.
75%
I have to confess that I overlooked it. I had not seen it till your lordships pointed it out. I need to also, I'll have a look at this also. And I can get the array of parties and the LPA also fine. Whatever your lordship says, otherwise I could continue with the.
No, because it's better that
No.
we.
So your lordship would want me to get the LPA filed by now? Should I file the LA?
File a copy of the
LPA with the array of.
The LPA as well as the earlier order, that 2822 order, that is already on record, I think. This 2822 is already there, 140 to 140.
Yes, yes.
And the 23/7/19 is also there,
Yes.
but we don't
Yes.
have a copy of the LPA.
We'll have that filed, my lord.
You are appearing for
Yes.
R1,
Yes.
Dwarakadish.
Yes. For Amit Chaturvedi.
Who is the director of this company?
Yes.
Madam.
And who had filed the appeal before the NCLAT.
And you did it in your individual capacity
He did it in his individual capacity.
against an order of admission of the CIL.
Yes.
Yes.
Yes, Your Lordships.
How are you entitled to do
Your
that?
Lordships also as a shareholder and the guarantor.
No, you filed it not as Amit Chaturvedi. You filed it in the name of Dwarakadish.
No, I filed it as Amit Chaturvedi.
Amit Chaturvedi.
Yes, Your Lordships. In the very first instance. Next.
Show us the
5A.
Your Lordships, I'll just show you the appeal.
5A.
Very well. You showed yourself
In
as
fact, my lord, this is happening in a lot of matters. The ex-promoters, whom your repeated judgments of your lordships have said that as far as possible keep them away, because they are the ones who grounded the company to dust, are the ones who most passionately pursue the case of the corporate debtor, and in most of them ultimately the court holds what is your locus and what are you doing in these
Your
matters.
Lordships, we'll prove it.
and you're appearing for whom?
For R2, who is the RP?
RPs. So now you are at least back in the saddle.
Yes.
But you have to keep the board of directors informed about
No
what.
further steps should be taken in terms of progress.
Your Lordship, page number 1206 shows the bill title. Is it Your Lordship, page number 1206?
So
Wednesday then.
Very well.
Next
Mark
Wednesday.
beside you.
Next Wednesday.
And page 1206 is the cost title.
Yes. Was that-
Of the
Manoj, let me check up about the 70% also. Let me come back with both the issues because this statement is made. But
Yes.
frankly, as I said, I had not had a look at. I'll just check this up. And what is the current status of the so-called consent of how many creditors is there? Let me just check that out.
Sure.
Very grateful.
item 14.
Lordship,
No count of
item 14, we have filed a counter last night.
last
The
night.
same may be come on the record seeking a short accommodation.
Who appears for the petition?
Lordship, I appear for the petitioner.
You need to file a rejoinder.
Please, Lordship, I'll need.
We are informed that a counter affidavit was filed yesterday. Registry is directed to verify and not be same. Full stop. Learned counsel for the petitioner seeks time to file a rejoinder to the aforestated counter. Equal in that regard shall be done within
2 weeks, Your Lordship.
2 weeks, based on 26th February.
Lordship, interim order to continue.
Earlier interim order dated 18/9/2025. Continue to operate till the next hearing.
Item 15.
We'll read from the Lordship.
15. We received a copy of the affidavit filed.
Your Lordship, the other side, the municipal council has filed the affidavit.
Affidavit showing that all the debris, everything is lying there, you've not removed.
Your Lordship,
it.
one
How much is the amount lying in deposit here?
Yes, please, Your Lordship.
Well, it's annual for respondent number 6, the councils for respondent number 2 and 3 per year.
5,36,100.
Thinking that the matter would go on.
That item 13 would go
So
on.
how much was the amount which was lying in deposit? I couldn't get the details.
5,36,450.
Well, they are saying that it cost them 16 lakhs to remove this.
Your Lordship, just one note.
No, but you gave us an undertaking that you would do
Yes,
that.
Your Lordship,
And then
that
you
is-
don't abide by the undertaking.
Your Lordship, I am just telling you one fact. The 72 shops has been demolished by me. Your Lordship,
Demolished doesn't mean that you leave everything there.
Your Lordship, just see the affidavit and photograph date of
Look
the
at the
photograph.
photographs.
Your Lordship, see the date of the photograph is of the 15th December 2025. The last order was passed on 16th December
Where did you find the
2025.
date on this?
At the bottom of the photographs, Your Lordship, the clicking date, the Monday is the last on the at the bottom.
Which
Your
page
Lordship.
are you looking?
Page 4 at bottom, Your Lordship.
At the bottom?
Bottom yellow. Where the description is given. January 2026.
Oh, this one. So this one is.
Description is there, the date is there, Your Lordship, Monday 15.
According to you, you've cleared everything, is it?
Your Lordship, the 16 was the last date. After the last date, the broken pillar was also removed. But the municipal, we have given the letter to the council also.
Why haven't you filed a copy of whatever?
Your Lordship, they have filed this affidavit just on Saturday, 24th January 2026. The 25th, 26th, the
How
vacation.
long does it take for you to take pictures and file them?
Your Lordship, I will file the affidavit, the better affidavit, Your Lordship, reply affidavit to this.
Are removed, not merely demolished.
Remove.
Admittedly, we are in the possession of the property. It's not the case where we have to hand over the possession to the other side.
Remove. File photograph then. Let us see what, according to you, is the present condition.
And the debris is in my property, Your Lordship. So,
Affidavit filed by respondent number 2, along with the photographs, is taken on record. Learned counsel for the petitioners seeks time to file his response thereto, along with supporting photographs, as it is his claim that the petitioners have not only demolished the construction but also removed the debris
No, Lordship, debris is, I'm not just saying that the broken pillar was removed as per the picture.
So you've left everything there.
Your Lordship, debris, I have no instruction from the client. I will
We
file
said
the affidavit.
remove the construction, which means that the land should be clear.
Your Lordship, just
So you do that now and then file a photograph. Then we'll see whether you're abiding by the undertaking.
so your Lordship, just don't record. Please don't record in the submission. I will file the affidavit.
Along with supporting photographs.
Photographs.
If we find that any debris is there, then obviously you're not.
But your Lordship, as per the High Court order, I am in the possession of the
Consequences will
property.
follow.
Thank you.
Advise your clients that they just can't take undertakings this lightly.
Plus, I need to give, permitted to give my physical appeal.
Yes.
Like,
Date, how much time do you require?
2 weeks, 4 weeks. Your Lordship.
26 February. Questions not filed.
May I plead your lordship, sir?
Mr. Attorney General.
Yeah, I've taken stock of the matter now. I've taken stock of the matter now. In fact, I sent a message to my learned friend, and we are preparing the process of preparing a status report. On many aspects, I think there have been some good work has been taken place. So let me give a status report in about 2 weeks' time. Then lordships can thereafter hear this matter.
Matter is just getting adjourned from time to time. There's
No, I have now taken stock.
Now
of the
we
matter.
have someone who wants to intervene and give some more suggestions.
Yeah.
Who's talking? Yeah? Have you received a copy of it, Mr. Mike? Someone filed an intervention petition.
No, I've not received.
We haven't received it.
Well, may I
There's an
suggest
intervention yesterday, I saw it.
speaking also, well,
No? It's 16 only.
this is of course happens
Intervention.
frequently, a Michael doesn't get it.
No,
They don't serve, they just file, I don't know how it works.
Okay. They stay in the circulation, it had come late at night. Or maybe it's in 16.1. 16.1 it may.
The whole of this, the party can lose it. The identity.
Yeah.
Separate application.
And 26. 25th and 26th, we have GM. That will be difficult. That's my
This report seems to mention it. 16.1 it was filed. And Mr. Ashwini Kumar.
second week.
Have you received a copy of the?
Yes or no?
2020.
My learned friends all confirmed they have not received.
Circulated. I saw one intervention application. Anyhow, the council is also not here.
Now, can I just take 2 minutes? Sanjay Michael, your lordship will put it sometime in March. It's there.
Very
I mean, two things. One, there is a written submission, the older one, filed in August of 25. Now, I have now changed the provisions to the BNS,
BNS.
which is subsequent. So, the same thing will be read, only the provisions will change. So, I made a 2-pager on the prayer, the recommendations which I am suggesting respectfully to the court.
Yeah.
That part only I will hand over and it can be circulated or given. It's the same thing.
Furnished it to the attorney also?
Attorney, I will just give it down because it's the sections basically change. I'll make sure he gets it. It's broad, it's almost identical, but for the sections. Number one. Number two, well, it's, I hope these inputs come in advance so we can make a chart. In the light of my written submissions, whatever inputs my learned friend, Mr. Attorney gives.
I propose to do that myself. We will try to do that.
Take in advance.
Yes.
Because my suggestions, where the guidelines is also before your lordships.
That's also communicated to the attorney?
Yes, that's all with it.
Please take note of all that has come.
I will collect all of them and see. Yes.
Whatever it is.
Milords, my only respectful submission is, Milords, the lordships know, Milords. It's a matter of highest priority. Lordships are hearing it in March. Any dates suitable to your lordships, Milords, may be kept because this will require some time, Milords, because the matter is so critically important. It has been pending since 2020. And I think now it will see the light of the day with the learned attorney now itself.
Attorney General, to file a status report, ensuring that advance copies are circulated to all the joint council appearing in the matter, including the ones from Baker Street.
4th of March.
Holidays.
4th March.
Holy break. Holy break.
Oh, holy.
18th March.
18th.
18th. Very, very well. Grateful to Lord.
Focus not served.
Some notice, sir. In item 15, your lordship, the may be date 25th February if your lordship is.
Sorry?
Convenient. Date may be 25th, 26th February your lordship is.
In which item?
15th.
15.
25th February it may be.
What have we given?
26th February.
26.
Working day,
25th is
Wednesday.
Or 24th.
Wednesday.
Any obligation.
I believe
the service is pending.
Service is pending is what I'm.
I appear for respondent number 90. We have received service.
No, but according to the office report,
The
service is not complete in all the matters.
It's on the post.
Now, there seems to be some issue about whether these 25 or 29. 29 mining lessees whom you said were free of
I've
any wrongdoing.
filed that report.
According to the other side, there seems to be some issue about it.
Not according to other side. There's an intervener, Lord, who has filed without even coming before the High Court. Intervener comes
But
here.
we also have your own officer backing out before the High
No,
Court.
that was only one. That was on the questions of the learned Chief Justice then, Lord, that the officer said
No,
something.
but did she do it voluntarily? Is she saying something that is contrary to
No,
the
but
record?
it is
What
contrary
are
to
we
the
doing?
record. Contrary to the
She's a
record.
signatory to
She's
that
a signatory
report.
to the report.
And then she says something contrary to
Correct,
what is stated in the
correct,
report. So
correct.
what do we do with that then?
No, that can't be once you have signed a report and five other officers have
We
signed
don't
the
know. The High Court, in fact, wanted to initiate contempt against you because you initiated disciplinary proceedings against
No,
her.
not disciplinary. We gave a show cause notice that having signed the report, how do you give contrary submissions before the High Court? So of course,
And
then of
what
course-
happened then?
No, then your
Maybe
lordship.
it's better that you ask that lady to come here and tell us what the real.
I have no issues, Lord.
Because it's better then, because we don't know whether she's being pressurized to give a false report.
My other five officers, Lord, would have signed
We
that.
don't know. We don't know what is happening.
तुझे भी तो खुद को बस थोड़ा लगाना है, तुझे भी तो खुद को बस थोड़ा जगाना है, खुद के वादों से ही तो जन्मा है, तुझसा ही निर्मा है, तुझसा ही निर्मा है। जिद्दी दागों के लिए निर्मा एडवांस।
मम्मी, दीदी, मेरा एडमिशन हो गया, मेरा एडमिशन हो गया। थैंक यू। मम्मी, कुछ दिनों में फीस भेजनी है, सब हो जाएगा ना?
तू बिल्कुल चिंता मत कर बेटू, सब हो जाएगा। तू तो बस उड़ान भरने की तैयारी कर।
जहां सपने उड़ान भरते हैं, एक विश्वास है जो उन्हें पंख देता है। अब विदेश पैसे भेजने का सर्वोत्तम उपाय SBI, हर देश में अपनों के साथ। अब इंटरनेशनल फंड्स ट्रांसफर, योनो, नेट बैंकिंग और सभी SBI शाखाओं पर उपलब्ध।
What is her name?
What is it?
The order.
I'll just tell your lordship. No, order only record.
Orders perhaps.
Order is Lakshman Singh, Additional Secretary, to whom the notice was issued.
There was one of the
DMO.
orders.
Lord, it refers to her as DMO.
DMO. Without mentioning the name.
Without mentioning
But her
the
name came somewhere, Mr. Atmara.
District Mining Officer. Para 2 onwards, Lord, District Mining Officer is
Is
present.
that On an earlier hearing, during an earlier hearing, you showed us the report.
Her name is Nazia Hassan.
Nazia Hassan. Miss Nazia Hassan, DMO,
JM.
District Mining Officer,
Lord, in fact, your
who
Lordship,
appeared before the High Court,
summon all these people who have summoned the reports.
shall be
They
present.
shall explain to your Lordship.
We don't want a free for all here now. She's the one who said something contrary to that report. Let her explain why she said it, whether she's being pressurized one way or the other. Shall be present before this court. The state shall bear the expenses for her to and fro travel and her boarding and lodging.
No, that is, she's a government servant, Lord.
Whatever.
In case
Because we are asking her to come, don't make her pay for.
Not at all. How can that once it's a court order?
So,
Under the rules, she's Lord, the interim release to continue.
earlier interim order shall continue till next hearing. This one, when shall we take it?
Somewhere in February, but except 11th to 13th. After that, or before
18.
18th.
18th.
Lordship, grateful.
Item 18.
One moment. One moment.
I want to make a small.
One moment.
Lordship, I was in item 16, respondent number 2.
Yeah.
I just seek permission to file physical appearance.
Please, my lords, I appear for the petitioner in item 18, my lords. The
Yes.
issue involved in this matter is, my lords, the entire criminal proceedings has been quashed by the High Court, my lords. My lords, may kindly have the impugned order at page 2,
Lord, yes,
last
again.
paragraph.
You're here?
Please, my lords.
Well. Yes.
My lords, may kindly have the impugned order, the last paragraph, my lords. My lords, have page 2.
Yes.
After aforementioned first information report was lodged, investigating
One
officer.
moment. Which order are you reading?
My lords, I'm reading the impugned order, page 2, my lords.
Page 2. Very
Please,
well. After
the last paragraph, my lords.
Yes.
After
Yes.
aforementioned first information report was lodged, investigating officer proceeded with the statutory investigation of concerned case crime number in terms of chapter so and so. He examined the first informant and other witnesses under section 161 of CRPC. The witness so examined have substantially supported the FIR. On the basis of the above, the other material collected by the investigating officer during the course of investigation, he came to the conclusion that the complexity of the all name accused established in the crime in question. He accordingly submitted the police report under section 173(2) of the CRPC dated 30th September 2022, whereby the aforementioned name accused have been charge sheeted under section 419 and 420 of the IPC. After submissions of the aforesaid police report, the concerned magistrate in exercise of jurisdiction under section 191B of CRPC took cognizance upon the same and registered a case. Consequently, the charge sheet accused applicants were summoned by the court below in crime number so and so arising out of crime number so and so under section 419 and 420 of IPC. By summoning order dated 14/11/22 passed by the Chief Judicial Magistrate Jaunpur. My lords, thereafter, the court on two grounds have quashed the proceeding. One is on the ground of delay and other relying on a judgment which was in pertaining to bank officials under the Surfacy Act, my lords. My lords, may kindly have the next para, just leave one para. Learned counsel for applicant has first invited attention of the court to the first information report giving rise to the present criminal proceeding. With reference to above, he submits that as per the prosecution story as unfolded in the first information report, the occurrence gave rise to the present criminal proceeding is alleged to have occurred on 10/10/2019. Well, that was the date when the checks were handed over to the accused person. Whereas the first information report was lodged on 17/6/22 after an expiry of more than 2 years and 8 months. He therefore submits that there is a delay in lodging the first information report. He neither in the first FIR nor in the statement the first informant recorded under section 161 of there is any explanation with regard to the delay in lodging the FIR. It is thus urged that since the delay in lodging the first information report has not been sufficiently explained, therefore the consequent criminal proceeding pending against the applicant arising out of the FIR cannot be sustained. Now, my lords, the judgment that they are relying upon is a judgment which was under 302 of the IPC, my lords, and it was after the trial when the parties were permitted to lead evidence. Whereas, my lords, here without any trial, without an opportunity of leading any evidence, this judgment has been applied in this case and it has been held to be beyond the limitation, my lords. Now, the relevant portion has been quoted, my lords. If my lords will see, it is the part of the judgment. Normally, the court may reject the case of the prosecution in case of an inordinate delay in lodging the first information report because of the possibility of the by the prosecution. However, if the delay is satisfactory, explain the court will decide the matter on merits.
Then there is two.
Yes.
Now, my lords, this is the part that they have quoted. My lords, now I'll take my lords. My lords may have page 5 and the third
next
paragraph.
after the extraction also.
Please, my lords.
It is then contended that.
Then contended that proceedings under section 131 of were initiated by Vinod Kumar against the first informant Chandrasekhar Bharti by way of a complaint number so and so. Malas, it's an admitted fact that they have initiated two proceedings against my client under 138, my lords, for these very checks, my lords. And I am participating in those proceedings, my lords. But my case is, my lords, for those.
But in the 2 years.
Malas, it was when I received bailable warrants in those cases, then I realized that they have misused the checks and then I filed a criminal complaint, my lords. And my lords, after investigation, the investigating officer has found material. In fact, my lords, they say I have given them 10 lakhs and some amount for purchase of land. But they have not shown even a single document along with their 138 proceedings or before this honorable court establishing whether there was a transaction or not. It's an admitted fact that the petitioner and the respondent
were. If you were summoned in 2020 itself.
No, my lords. He was summoned only in 2022, my lords. He received the non-bailable warrants on my lords in 2022, and thereafter he filed.
Warrant would be later. When was the summons issued?
My lords, he did not receive the summons. In fact, he did not even get the legal. My lords, may kindly consider that the period of when the checks were presented.
It must have been served.
Why would a NBW be issued unless summons was served?
My lords, may kindly consider, my lords, what had happened was this was the COVID period, my lords. The checks were presented on 16 January 2020 and 24th February 2020, my lords. Therefore, my lords, March onwards there was a COVID situation, my lords.
January and
my lords, first check was presented on 16 January 2020 for 10 lakhs by Lakshmi Narayan. The check number is 21005820.
And
the second was on 24th February 2020. The check amount was 3,50,000 and it was by Vinod Kumar. The check number is 21005810, my lords.
And when was the case filed? Complaint case?
My lords, that they will have to explain. Those dates are not coming in their reply, my lords. But I got to know only on 11/4/2022, my lords, when bailable warrants were served upon me, my lords. My lords, may kindly consider during that period the COVID was going on.
Is the order issuing the NBW against you available?
No, my lords, it is not on record. My lords, if my lords want, I can
file it. How do we know whether the service of summons took place or not?
Finance of a vehicle to be
My lords, my complaint is there, which is at page 37, after which I have filed, my lords.
To you gave the money to them for purchase of a vehicle.
Yes, no, my lords. I gave them those checks to arrange a vehicle for me, my lords. That they were my friends, my lords. They were known to each other, my lords. They said
You're an advocate, they are teachers.
no, well, they are teachers, but they were known to each other. In fact, their case is also that we were known to each other's, my lords. In fact, their stand why the money was given is contradictory,
Transaction
my
is
lords.
entirely different as projected by them.
My lords,
You're not even on the same page there.
No, 2019 she admits that she wanted to purchase he wanted to purchase.
Vehicle then.
There's no vehicle purchased.
No, my lords. Subsequently, a vehicle was purchased, my lords, by himself. They did not arrange for any loan or any vehicle, my lords. My lords, may kindly look at this stand.
Madam, wait a minute. You did not get a vehicle.
From them, yes, my lords. They did not arrange the vehicle. I, on my own, arranged it subsequently.
Okay. So in 2019, you gave them 5 checks for arranging a vehicle on finance. So then if it was not arranged within 6 months, you should have filed an FIR then and why did you wait till 1
My lords, may kindly consider that was a COVID period. My lords, March 2020, COVID started and everybody was...
10/10/2019, March 2020, that is almost 6 months thereafter.
My lords, that's what I'm saying. The checks were only presented on 16th January 2020.
Madam, we are asking you something else. You say that you handed over the checks on 10/10/2019 for the purpose of purchasing a vehicle.
Please,
admittedly, no vehicle was purchased. Why did you not initiate proceedings then and there?
My lords, may kindly, that's what I'm saying, my lords. The checks, in fact, these questions are matter of trial, my lords. He's going to lead evidence. If there is no evidence, his complaint will be dismissed in any case, my lords.
Story also sounds a little difficult.
My lords, may kindly see their story, my lords.
Being an advocate, expect these teachers to arrange a vehicle for you.
My lords, they were known to us, my lord. That is why. My lords, may kindly look at page 75 of my SLP,
According
my lords.
to them, you said that you would provide money, provide land to them. You took their money.
My lords, that's what I'm saying.
That, you gave them checks.
My lords, may kindly look at their stand.
That sounds more plausible there.
My lords, may kindly have their stand before the High Court at page 75, my lords. The stand was entirely different before High Court is what has been stated before this court, my lords. My lords, may kindly have page 75. My lords, it is...
story though, and there's delay. On the face of it, there's clear delay. The application of a judgment.
My lords, whether there is a delay or not delay, my lords, it's a matter of trial. As on date, my lords, I can explain that delay. My lords, may kindly have page 75. My lords, may just one point I'll show, my lords, and then I will not push, my lords. My lords, may have page 75, my lords.
75.
Para 7, my lords.
Yes.
My lords, it is their petition before the High Court where they were seeking quashing that initially the opposite party number 2, my lords, that is my client, taken the money as a borrow for the purpose of initiation of the business. And when the petitioner demanded given check mentioned in the first information report, the same has been presented before the bank, the faucet was dishonored. So, my lords, the stand before the High Court is completely different from what has been stated before this honorable court, my lords. It is a relevant factor, my lords, that they have not been explained.
So they are entitled to take divergent stance in the proceedings.
My lords, their stand, my lords, they have not even, my lords, they have not even shown any document showing that I have given them 10 lakhs of rupees in.
We find no good ground and reason to interfere with the interim judgment passed.
Because I am covered by a judgment of this honorable court only on this, my lords.
These matters, precedents don't apply. the criminal cases and all will have to turn on the individual facts.
My lords, we have
I'm so
instructions
grateful,
to
my lords.
ignore the present specially
Which
petition.
one?
Item 19.
19. Then Councillor, what is your name, Councillor?
My lords, Bharat Sood. On behalf of Mr. P.S. Sudhir.
Mr. Bharat Singh.
Bharat Sood.
Bharat Sood. Mr. Bharat Sood, Learned Councillor. Give it in writing, please.
Yes.
Learned Council representing Mr. P.S. Sudhir, Learned Advocate on record for the petitioner, states on instructions that the petitioner wishes to withdraw the special petition. According to the said statement, the special petition is dismissed as withdrawn.
Right.
Grateful.
20.
No, sir. Because
Is there? Where is it?
It was the
You
same.
received the trial court record?
no, sir.
Yes, we had seen, we have gone through, and
Because last time the order was that
my learned
you had
friend,
not been provided.
my learned friend did
So
that.
you've received it. Yes.
But yes, we tried, Milord, on 25th, we had filed the return submission, same, Milord. Yes, Milord, I crossed the Nepal border, which is just at a distance of 20 meters. And Milord, I was just taken in custody in the evening itself and wrongfully confined on 5th itself.
No endorsement.
No,
Let him complete thereafter.
Lord, endorsement may see now the passport as my lord has asked for the original passport.
No, but the original passport is given.
This Lord, it's only the Nepal immigration stamp is of 5th.
No, but if there's no immigration stamp for the
India, that is what, Lord, because I was taken into custody wrongfully confined.
Into custody, he has
You will
to
have
produce
to
a-
come into the country before you are taken into custody, is it not?
Which one? That is what, Lord.
They can't take you into custody without first
That
letting
is
you
what,
enter
that is
India.
what, that is what they have taken now, Lord, how I am in custody, because in the morning they are showing that I
I don't
am.
know how these immigration offices work there.
That is what, because I,
Nepal is considered to be the most porous border. That's
Lord,
why everyone comes in through Nepal.
Lord, I may point it out. I did not allow, I was not taken into wrongfully confinement, Lord, in the Lord, in the no man's land. That is what their case is.
Date you said?
5th of November, Lord, page
5th of November?
2016. Lord, I crossed the Nepal border. Lord, the immigration stamp is there. Then it is their case that.
One moment, let us just see the entire passport because you have two visas from India also last time.
That's Lord, the one is a valid visa.
29.
At page 29 is the valid visa.
5th of November.
5th of November, page 11.
You keep
of the
going back
passport.
and forth on this.
Yes, Lord, I am with the business visa, my Lord. I am.
He's going back and forth.
Lord, it is a business visa with me.
Well, Nepal.
In theory, you may think of God as the creator, and he is the personal creator of paradise and the central universe of perfection. But the universes of time and space are all created and organized by the paradise core of the Creator Sons. The Universal Father is not the personal creator of the local universe of Nebadon.
इंडेक्स में देखिएगा पूर्ण से
Index the copy of the passport only, 188, 189. This part of it is in
Lord Macy, page 195, trial court record, on the top handwritten.
195.
22.
And Lord, this, as per the story and the side plan is all different.
Page do you want us to look at?
130, 130. That is on the PDF.
No.
The original.
This is running in pagination.
No, you are seeing it from another paper.
Trial court record. Lord, I am referring, Lord,
one might be.
it's exhibit, Lord, exhibit K5. I'm sorry, Lord.
130. 135.
130. Side plan. He has been arrested inside the India, not in the no man's land.
130.
Yeah. Item 22, ma'am.
130.
Item 20.
130 of the, Lord, the typed copy.
Days of occurrence.
Translation.
What is SSB check post?
Inside the Indian.
Oh, what is it?
Seema Sashaktra. Seema Sureksha.
Seema. But where is the immigration post then? That's the immigration post. Immigration is also SSB.
No, my Lord, immigration is different. That is what, Lord, day before yesterday I was seeing the satellite. It is, Lord, just this one, 200 meters inside from the no man's land.
Place of occurrence, India Gate.
So before the, you caught him in the no man's land. No, inside the India.
Lord, look at the FIR itself.
How do you arrest him without at least putting the immigration stamp for him to enter into India?
So you say the place of occurrence is A. That is before the SSB checkpost.
সেবাশ্রয় ক্যাম্পে আমি চোখ দেখিয়েছিলাম, ওখান থেকে আমাকে অপারেশনের জন্য পাঠিয়েছে। এই অপারেশনটা আমার খুব ভালোভাবে হয়েছে।
আমি এখন ভালোই আছি। এই অপারেশনের জন্য আমি অভিষেক বন্দ্যোপাধ্যায়কে খুব ধন্যবাদ জানাচ্ছি।
প্রতিশ্রুতি পূরণের এক নাম সেবাশ্রয় 2।
হলতার শিবিরে আসা ২৭ জন মানুষ ফিরে পেলেন স্বচ্ছ দৃষ্টি। রেণুকা আই ইনস্টিটিউটে বিনামূল্যে ছানি অপারেশনের মাধ্যমে তাদের জীবনে ফিরল আশার আলো। মানুষের কল্যাণার্থে আমাদের এই প্রয়াস চলবে অবিরাম। সুস্বাস্থ্যের অঙ্গীকার, সুস্থ জীবন সবার।
Of the gate is there.
Oh,
So
this police check post C is India's check post.
Yes.
Yeah, okay. Then how did he get in without stamping?
Yes. How do you arrest a person if he's not even in India?
No, he was in India.
He is not in India in terms of the passport. There's a Nepal
That is what he said.
departure stamp there. There's no entry stamp on the Indian side.
See, if you caught him on the no man's land, definitely you should produce him before the immigration authorities and get his passport stamped before taking him inside. Now you say that he was inside India, and that too very near the check post also. So it is not a not as if he did not pass through the check post. If you say that he had come through the check post, then definitely it would have been stamped.
And this, according to you, happened on 6th.
Six.
How is that possible? He left on 5th. So he slept in that no man's land the night.
He left Nepal on 5th, but there is no entry of the on 6th to enter into the India. See, there is nothing on record.
I hope you are understanding what we are trying to tell you. See, if he has entered India on 5th or 6th, whatever it is, his passport would have been stamped. So the possibility is that he was arrested in no man's land, and you did not, probably seeing that he was in police custody, the immigration officials would also have not been very careful. You ought to have produced him at the immigration council and got it stamped if it was in no man's land. Now, when you say that he was in India, then how did he get inside India? Passing through the check post.
Whatever the record.
That's all. Because
whatever the record.
Lord, the FIR says no man's land.
FIR says no
man's land.
Then you
FIR also says no man's land.
That is what Millard. May I read the 4th line in the page 31 of the typed copy, translated copy, Millard.
In the record or
record, Millard, trial court record.
This one. No.
Trial court record in a type, Millard. There is a different.
It's 31.
Page 31.
Page 31. Type 1, Millard, the translated version.
Yes.
May see, Millard, the 4th line. 3rd line starts. I, the Sub-Inspector Rajpur Singh, while checking suspicious person's vehicle, reached at the main India gate situated on the India border on the no man's land. Under Sonali.
In the India border on the near, not on
east side of India gate.
See, no man's land is not within India. Please understand that.
Yes.
There is always.
But border is just to enter. When you enter, there would be a border.
Council, we are asking you two things. If you had arrested him within India, as you say, just before India gate, he would have passed the immigration. Then he would have stamped his visa. But if you arrested him no man's land, you should have ensured that his visa is stamped. That also you didn't do. So then the only thing is some hanky-panky.
Whatever record.
But how do we sustain your entire exercise if this man is not shown to have entered India at all?
Whatever records I have.
And this objection was
the reason as to why we have all this procedure, is it not? Immigration, everything. You, according to the FIR, you picked him up in the no man's land.
No, she no.
He's
the man India did.
A foreign national was entering India from the north direction, stopped by the SSP force.
At around 7
So therefore, you, and on the earlier part, you said that it was on no man's land. You specifically said so.
Why child because check was situated on the border, on the no man's land, but he had been arrested.
You cannot arrest him
At
without
around
at
7,
least
7 a.m. in the
putting
morning.
the immigration stamp to show that he has entered India. When he's in no man's land, he's not in India.
May I read further? At about 7 a.m. in the morning, a foreign national was entering India from the north direction towards Nepal in the south direction. On the basis of suspicion, that foreign national was stopped by the SLP force. And while searching the bag and belongings, it was found that he was hiding illegal hashish in the bag.
See, Counsel, your FIR says no man's land. You arrest him. If you have to bring him inside India, you should have produced him before the immigration authorities and stamped the passport.
Nothing on record. Whatever the record.
That's the right way of doing it.
This was not the first time raised. The very first opportunity this was objection was raised. Lord Macy, page 230 for the trial court record.
The same volume.
230 of the trial. There are different files. One is a translate this one as it is the trial court record. That is below at page 230.
From handwritten.
With the handwritten it is 230. Where the letter is there, and before that it is what very important 229. And I put the typed copy also. May see this just 3 lines. And the order also says the honorable judge was not there when the charge sheet was filed. And that is what it corroborates with the what he has said it on this date.
Say in the FIR that there was a dog. You don't.
But dog knows for procedure around about 23 lakhs. The which we had cut the cost of 23 lakhs.
That is a different matter altogether. What we are asking you is, when you record an FAS, you should say the entire things that he was coming with a dog and all that. If at all it has to be done. 23 lakhs, see, in the border, you have no difficulty in getting such confinement. If somebody brings in 3 kilos, you keep some for the other purposes. We all know what's happening there also.
But the addition then because of dog, because of dog, we have fabricated but a person.
Also, quite enterprising people, your officers also.
Where was he coming from? Nepal?
From Nepal, that is
Nepal, which place?
Sonoli border.
Where are you coming from?
Coming from Nepal side towards stamp is of this one Sonoli before the Sonoli border.
L-BHA.
That is what the immigration Nepal is. That is Nepal immigration. They are not specifying the place, but it is same, Milord. That is what in the morning they have shown me arrested in the morning. He had come by bus. That is what the bus ticket has been filed. And Lord, this letter which I am showing at page 230. Lord,
Judgment also.
Milord, for a moment. The judgment, Milord, as far as that entry is concerned, this is a minor contradiction because it's an admission by PW1.
What is the other evidence that, what you call dealt with? You have already told us about the entry in this thing. What is the other evidence dealt with in the judgment?
Other evidence against me. There's no other evidence. That's the statement of PW1, 2 and 3. And that is also contradictory.
Let us see PW 1, 2 and 3.
Please, Milord. I'd annex the typed copy also. Milord, may I just take it to the Hindi version, Milord? That would be in the, Milord, which we have filed before this honorable court.
English version also is filed.
Sorry?
English version is also filed.
Unless there's a specific portion which you need to show us in Hindi.
That's it. Milord, in fact, my marking is because...
61 for the trial court is got. Page 61.
Sorry?
Page 61.
Of the
file SLP.
Trial court.
Trial court.
Page 61.
SLP also it is produced. Tell us where it is.
Complete deposition necessary in the trial.
Complete deposition is page 61 of the trial court.
Milord,
51 is the order.
61.
61, Milord, is the...
61.
You have produced PW 1 to 5 in annexure P4, correct?
Yes, Milord.
That is there, sir.
Yes, Milord, I had annexed. But it is the High Court translation, Milord, it is at page...
High Court translation.
It has page 61.
You have gone through it from page 42 onwards, it is there. Correct?
The dates are incorrect in motion.
There's so many people around him and he doesn't. See, we are looking at that file. Your SLP file.
Yes, Milord, I may.
Look at annexure P4.
Yes, Milord.
Dates are correctly mentioned in the page 42.
42 onwards.
Incorrectly mentioned. 1/5/2014 is 1/5/2017. 1/5/2014 is written down. It is 1/5/2017.
Page 42.
1/5/2017. Oh. Let us read that. Let us read that. Just wait a minute.
Yes, Milord, it is.
We'll read that. We'll read that.
1/5/2014.
17.
17.
There is
Here at the top it says 1/5/2014.
That must be a mistake.
Correct translation is page 61 of the trial court report. Correct translation of the PW1.
No, it can't be so. See,
It must be
there is 2000. The special case 1. Then it's given before court, correct?
Yes, Milord, that is
okay. So PW1 SI Raj Prakash Singh did not see the contraband being recovered from him. By the time he reached there, everything was recovered. Wait, this is not PW1.
This narration, most of these cases, this is how the IOs give evidence. As if as soon as the accused sees a police officer, Harish Chandra takes over him and he speaks the truth. And he says, I have bought hashish from so-and-so, I have brought it to sell. So they confess everything and they say, we trust you. The police also need to be a little mindful of how they give evidence, isn't it? Are we supposed to believe that as soon as they see a uniform, all accused start quaking in their shoes and tell the truth straight away? Or is it after you give them the treatment?
See, he was accosted by Inspector A. Rajakumar, Constable Vinod Kumar, Constable Yug Bahadur Garu.
Are they examined?
Are any of them examined?
Raj Prakash Singh.
Rajkumar Singh was in the other part.
Yes, ma'am.
All they have been examined.
Vinod Kumar is the
Madam.
Vinod Kumar.
PW2. Let us see.
A Raja.
Wait,
Not A Raja.
wait.
Vinod Kumar, Head Constable, SI A Rajkumar, SI Leftesh Yadav,
Wait.
Vinod Kumar is there.
There are minor distribution.
Was not correct.
See, it is after the recovery that you search each other. That again is.
Where is Raja Kumar or whatever his
EW3 Milord.
EW?
No, but he says I was present at my office residence. So he's in fact all three people are not the witnesses of recovery. Three people have been taken as witness of recovery. All three are giving different versions, and none of them have claimed that the church has been recovered by them.
Their statements are also not gelling.
A Rajkumar is the.
A Rajkumar is.
Page 56.
But what Rajkumar is supposed to have said at page 44 is different from what Rajkumar himself says. The consent letter at page 44 ending.
44
ending. Out will have to go. You will have to advise your people to be a little more.
Do one.
Not minor contradiction.
All
minor.
Before the timing, which we
immigration entry.
I would have
Less than the better.
with this point.
See, first thing you would look at a foreign national is a passport. And if he had not entered it, you should have gone there and got it entered. That you didn't do. You caught him near the no man's India gate. Then if he had not entered.
And immigration stamp in Nepal would have been put when he was leaving the border. They don't put it in Kathmandu and send him on a bus. The immigration stamp would be put at the border when he's crossing Nepal. So if he did that on 5th, you obviously must have come in on 5th. Less said the better about
And they all the witnesses talk about the dog. If it was there, he should have specifically mentioned it in your Mahasar also.
Arguments concluded, judgment is there.
The written submissions also have been giving each and every point.
Your dog was how old when you lost it?
What
have you done with this dog? He named it also, he gave it also an Indian name. He seems to have been in India most of the time.
Because of dog, he is not firstly implicated. Because of dog, he was not.
You liked his dog, that's why you caught him.
23 lakhs of the top.
Individually, don't tell us all that. The enterprising people, they can solve the daily basis.
That's deeply obliged.
21.
Madam, send me.
আচ্ছা শোনো, যদি আমি মরে যাই তাহলে তুমি কি করবে?
তুমি যদি মরে যাও তাহলে আমিও মরে যাব।
সো সুইট।
এত খুশি আমি কি করে সহ্য করব? বেস্ট ফার্ম গুগলি এর টেস্টে আছে টুইস্ট।
Matters which are capable of being disposed of quickly, we can take up in the miscellaneous here. Not matters where there are 7 volumes to be gone through.
That can be disregarded.
No, that can be disregarded once we file it. You can join the queue list.
We have just filed convenient compilation encapsulating whatever is essential.
We've granted without list for hearing in the list of regular hearing matters on 15th April.
15th April.
Once you join the queue, you'll have your turn.
Grateful. Can we pray for March?
Hardly a judicial time.
Yes, we had been waiting for a decade.
February will come only in the.
For something in the alternative minutes. Without granting leave, could my lords hear that matter anywhere?
No, it's better that we grant leave so that you join the queue. There are people who are waiting patiently. How do we justify you jumping the queue?
My money admitted and
whatever it is, you'll have to join the queue.
Great. Okay. We're always filing for 5 minutes.
22.
Millets will file our submissions, Millets written submissions.
Written submissions may be filed.
Great. Your Honor, item number 22.1, I have not received the copy of counter affidavit they have filed. Even as per the office report.
Yesterday there was one counter which was given, which is deposed to on 27th October 25. But it was given yesterday night during circulation.
I'm so sorry, Lord, but in fact, the other counsel, I gave it the copy in the court itself. I'll again give.
You have
we have not received.
27th October.
No, Your Honor.
You don't have that.
Because I have filed a counter in one case, my lord, I am adopting it in all.
No, but he's not received.
I'll give you. If the previous one is adopted, I have received that.
Which one?
That's what I said. Copy I have received.
27th October.
On previous copy I have received. Yes, on the earlier date itself, I said
No, but this copy was given to me last night during the circulation. I don't know why it came.
But we had filed it, my lord, on 27th of October itself.
Because the email perhaps attached to it says 27.
Yes.
But yesterday it came late last night.
Must be some mistake in the registry, my lord, because we had filed it on 27th.
Well, you've received this copy. This
Yeah,
is the only
this
one.
copy we have received.
You need to file a rejoinder to this.
Yes, Your Honor, I need time to file the rejoinder.
Son counsel for the petitioner. Petitioners, it's time to file a rejoinder to the counter affidavit dated 27/10/2025. Equal in that regard shall be done within 2-3 weeks based on 19th March. 23.
The Lordship, I am seeking the short passover in this matter.
Password.
Okay.
24.
24.
My lords.
You're supposed, what happened to your applications before the High Court?
Lords, the High Court for some reason is not taking it up. Lords, I will ask them also, I had requested. I think they are worried because of the pendency of the SNP. The Lordship will direct them to dispose it off in 4 weeks.
Said so, perhaps.
I think that order I was seeking last
We
time.
informed that pursuant to our order, the petitioners have filed applications before the High Court. They seek some time to enable them to pursue the matter before the High Court. What more do we have?
For some reason, he is not taking it up. We'll just give a request the High Court to dispose it off within 4 weeks.
Applications have been filed before the High Court, but the same are not being taken up. Perhaps under the misconception that the same need to await the result of the special petition. We make it clear that pendency of the special petition shall not preclude the High Court from considering the aforestated applications filed pursuant to our earlier order dated 6/2/2024.
But the little time bound, any specific date?
We can't directly.
Leave it.
We made it clear that this SLP does not preclude the High Court.
I'll press upon him to dispose it off.
Yes.
In fact, I have said that it's a nullity and abated minutes, so he should.
List on 15th April. Meanwhile, you pursue the.
Very grateful. Very
It has to be substituted. Application is there.
Application is there, substitution applications.
Because I filed it here by appendant caution, but actually because he had died in the High Court, so I moved there. Yeah, I moved there, Minas. For setting aside the abatement and also.
25.
Service is incomplete upon the proposed LRs.
No alternate address is available. I will take steps to effectuate the service through alternate method.
Thank you. Office report dated 27/1/2026 reflects that service is incomplete. So far as proposed legal representatives number 2.3 and 2.5 are concerned. Joint counsel for the petition takes time to take necessary steps in that regard.
Like yesterday's letter.
Yes, Ron.
আজ সাধারণতন্ত্র দিবস। আমাদের গর্ব ভারতের সংবিধান, আমাদের অহংকার আমাদের গণতন্ত্র। কিন্তু আজ দেশের সংবিধান ও গণতন্ত্র এবং মানুষের ভোটাধিকার যখন বিপন্ন, তখন বাংলাই দেখায় পথ।
বাবা সাহেব আম্বেদকরের সংবিধানকে আমরা মানি, এটাই ভারতবর্ষের গণতন্ত্রের স্তম্ভ এবং পীঠস্থান। আজকে পদে পদে সেই সংবিধানকে লাঞ্ছিত করা হচ্ছে, মানুষকে বঞ্চিত করা হচ্ছে, অধিকার কেড়ে নেওয়া হচ্ছে।
জননেত্রী মমতা বন্দ্যোপাধ্যায়ের আদর্শে এবং জননেতা অভিষেক বন্দ্যোপাধ্যায়ের সেনাপতিত্বে আমরা লড়ছি মানুষের সার্বভৌমত্ব আর গণতন্ত্রকে বাঁচাতে, ধর্মনিরপেক্ষ ও সমাজতান্ত্রিক ভারত গড়ার লক্ষ্যে। মানুষের মৌলিক অধিকার রক্ষায় তৃণমূল কংগ্রেস সর্বদা অতন্দ্র প্রহরী। আসুন এই লড়াইতে আমরা সবাই ঐক্যবদ্ধ হই।
Right. It's not a escape. It's emotion. Into the air. Into the land. Into you. Ride. Because riding is remembering something eternal. Buried deep inside the forests of your soul. Harley Davidson X440T. Right back to you.
This Tom, how much time do you require?
2 weeks.
20, 30 minutes.
26. My lords, this is an SUP by the government where there are 3 orders against me, no doubt. However, my lords have given an order of notice and status quo, and I'll point out to my lords how the errors are corrected. My lords, this issue relates to a parcel of 1.45 acres of land. There was the predecessors of the present respondent originally owned 5.79 acres, out of which 4.34 was undoubtedly, admittedly acquired in 1957. The present issue, my lords, deals with 1.45 acres of land, which it is the government's case, my lord, was also acquired in 58, and we have sufficient documents to prove it. Now, my lords, be that as it may, because certain documents were produced belatedly, etc., I will come to that later. The point is that in 2001, an original suit comes to be filed seeking a bare injunction for rectification of revenue records. It is asserted in the suit that the respondent herein has been in continuous possession of this land since 1958, pursuant to an acquisition of a certain portion of it. This present 1.45 acres has remained in his possession. However, to support this, the fact that he is asserting, not a single shred of evidence is placed to show his continuous possession. No revenue receipt, no proof of cultivation, no nothing. And my lords may then see that in this suit, how it is decreed, my lords. My lords, the decree starts at page 82, and my lords may just straight away come to the issues at page 87, my lords, in a suit.
Yes?
My lords have that. May I read the issues, my lords?
There are no issues there.
Yes, my lords. This is the first stage of perversity. My lords, the state is not at all blameless. We have been remiss in certain documents. But when a plaintiff files a suit and makes an assertion, he puts forth a fact. He has to put documents to prove that fact. Accordingly, the trial court will frame issues, my lords. And what are these issues, my lords? May I read? In my humble submission, the first issue ought to have been, has he proved his possession? But nothing. Based on these issues and based on bare averments, this suit is decreed against me, saying since he says he is in possession and he was at one point the owner, and the government has, and in fact, my lords, the owners, they shift to the defendant to say it is on the government to show that they had acquired the land.
No, but if you claim that it was acquired, the burden would be on you to show.
My lords, we do not claim. It is our revenue record which reflects it is government land.
The revenue record itself reflects that it was acquired.
Suit. For a mandate.
Reflects the details of the acquisition.
No, my lords, but it is government classifies it as government Porambok land.
Very.
So now when the plaintiff files a suit seeking a bare mandatory injunction, this is not a declaration suit, it is a mandatory injunction to rectify the revenue record. It is for him to prove that the revenue record ought to be in his name. And my lords, to do that, what are the 2 elements? First is title, second is possession. The Honorable, the learned trial court ought to have looked into it. They do not frame a single issue in this way.
Suit is decreed.
They simply decree it. And based on the fact, because they shift the onus on the defendant to prove that he is not the owner, which in my humble submission, my lords, is not what is envisaged in such a proceeding. Which starts, the starting point for which, my lords, is a revenue record classifying it as government Porambok. Second, my lords, there is no prayer made for declaration of title in the suit. However, it is decreed holding him to be the title holder and the possessor, and therefore a mandatory injunction for rectification of revenue record is given.
Decrease title. Then you filed an appeal.
In appeal, my lords.
How does the appellate court deal with it?
My lords, the appellate court, unfortunately, now we can say in some way that the burden has shifted to me. Yes, my lords. My lords, the plaintiff, my lords, will find it at, my lords, page, it is page 70, my lords.
70.
Page 68 it starts. I can take my lords through it. My lords may first have page 70. My lords may actually just have para 3 at page 69. These are the bare above, my lords. May I read, my lords?
69.
Page 69, para 3.
Yes.
The plaintiff's ancestors, including his grandfather, late so-and-so and father so-and-so, owned and possessed an extent of acres 5.79, inclusive of plain scheduled land in RS number 255/225/3A, black cotton soil cultivable land as per entries in the revenue registers of the then Belfara Taluk and also subsequent records. During the minority of the plaintiff, after his father's death, in the revenue records, the plaintiff's name was entered as owner and pattadar, represented by his mother and guardian late Budimma, who was continuing in possession and enjoyment. After the state of Andhra Pradesh was formed, an extent of 4.35 acres was acquired in the year 1957 by the defendant for Budameru flood diversion channel out of the said land of 5.79 acres, leaving the plain scheduled land for the plaintiff, which is continuing in his exclusive possession and enjoyment as of right. The plaintiff does not own or possess any other land anywhere in the country. While so, the plaintiff learned during the year 2001 that the plain scheduled land is noted as government forum road in revenue records, though he has been actually continuing in his exclusive possession and enjoyment as his own private land as per the settlement register also. It is submitted.
Schedule is not finished. Schedule is not there because there is no digital.
May I make a suggestion which will perhaps save some time?
For the 5.7.
What is the suggestion you want?
Yes, my lords. My lords, one of the reasons the trial court perhaps non-suits me is that I was not able to show to produce the full record of the acquisition of this land. My lord, subsequently I have got it. I tried to produce it before the High Court, but then the High Court has gone on a misconceived understanding of Indore Development Authority and says you have not shown compensation, hence anyway you could not be hold title, which is obviously wrong.
Which paragraph is that?
Of the High Court, my lords. My lords may have page 27. Let me have page 28 first. Sorry, page 27.
27.
Yes, ma'am. My lords, towards the bottom of the page.
27.
Yes, my lords. About 12 lines from the bottom, my lords, as one could see from the pleadings. Do my lords have that?
Yes.
As one could see from the pleadings, the oral and documentary evidence and the judgments of the trial court and the first appellate court that there is no material to show that government paid compensation to the plaintiff with reference to acquisition of plain scheduled land. Even in the present petition, it is not the case of the government that it paid compensation.
No, but where is the reference to the material that you produced?
My lords, the references are throughout. My lords may have Page 26, the submission. And then I'll take my notes. We have annexed the material here also. I'll show the material.
Before they are walking.
Page
Support of this petition stating that 1.4 is passed by the land acquisition.
I can take my notes through the documents. We have annexed them here.
What documents have you filed?
My notes showing our acquisition as well as possession of this land, my lords. We first have the award, my lords, which is annexure P2 at page 48, my lords.
48.
It begins at page 48. This is the award.
Where is this?
My lords, this is award number 8 of 1958.
Very well.
Page 48, annexure P2.
Where is the reference to this?
My lords, in the third line, my lords will see acquisition of survey number 225/3A.
Yes.
And then thereafter, my lords, we come to page 50.
Yes.
Apportionment, my lords have the heading.
Yes.
Survey number 225/3A, 1.45 acres. This belongs to Koganti Jagannath Rao. It is his ancestral property. It has come to his...
Who is the Jagannath Rao? He is the person.
He is the predecessor of the...
He is the plaintiff. He is the plaintiff one.
He is the plaintiff himself.
Plaintiff in the suit.
At page 50, slightly see the second paragraph also. Second paragraph in page 50 minutes. This document is not part of the record, but however...
Yes.
Share and detail. This is another survey number.
Yes.
227/20 dash.
No, my lord. This is 225/3A.
This is one. The next paragraph is 227.
My lord, I think the respondents council is talking about the second para in page 50 at the top, my lords. It says all the lands except RS number 225/3A were taken possession by PWD on 1/9/57. And hence interest will be at so and so. So, my lords, as I had indicated earlier.
So possession was taken prior to the award. So therefore,
No, my lords. No, my lords.
No, not this land.
Yes.
The other land.
The other land had a separate.
Therefore, you say that for those lands, interest will be paid, not for this land.
Yes, my lord.
Because possession was not taken.
Yeah, that is other set of lands, other portion of this land. Then place it in the context.
Let us see what he has to say. Yes, to begin with, your suit relief itself is unheard of. Mandatory injunction to rectify the revenue record without first asking for declaration of title, no proof of title, no document filed, nothing, and the trial court gives you a declaration of title. You don't even pay court fee for it. So you pay court fee for a rectification by way of a mandatory injunction. And thereafter, there is evidence now to show that this land is acquired.
My lords, may I just
Even if they did not take possession, once it is acquired, it is acquired. You have a right to ask for compensation. That's a different issue.
They never acquired this land, my lords.
Well, there's a mention of it. This award is there.
No, who says that the entire out of entire property, just a portion was acquired? You say that in your plea.
No,
out of 5.7.
You admit the fact that
that is a different acquisition.
No.
Where is that document? Did you file it?
You specifically say that out of a total 5.79 acres, 4.45 was acquired.
Yes.
And the balance remained with you. That is your specific contention in the plaintiff.
Yes.
Who has
document
established that?
Yes, my lords.
No
Who has to
document
establish
filed.
that?
No,
Along with your plaint, did you file a copy of the award in relation to that 4 acres, 35 cents or gundas or whatever it is?
with the government and there is no dispute, my lords. Even the government is saying so.
You approach the trial court for a relief. You need to substantiate it. Is it not?
My lords, I may specify something.
Where is the evidence to show anything at all?
My lords, may I...
And on what basis do you secure a declaration of title in a mandatory injunction suit?
My lords, this may clarify one thing, my lords.
The High Court seems to have proceeded on the basis that they have not proved their return statement. How can that be?
No, it is not on that basis, my lords.
That is exactly what the High Court says in paragraph 29.
If your lordship sees the original claim that I filed, look at my specific government, my lords. for all throughout, from all times immemorial, my lords, the revenue records always showed my ancestors, later my father, and thereafter me as the possessor of the land. Land acquisition happened only with regard to a particular extent, my lords. Now, only
completely direct of.
Lords, only one particular revenue entry was added in my thing, showing it as an approach road, not government land.
This decree cannot stand.
May I explain one thing?
Suggest, my lords, my evidence was not before the
Why
court.
do you want a remand, madam? Yes, and what you.
My lords, none of these documents are part of the record. It's a civil suit.
Your prayer itself is misconceived.
Lords,
And the relief granted to you is worse.
Lords, revenue record, why can't it be corrected? Because they mentioned it as an approach road, not government land.
We need
It is not government land.
maintain a suit for rectification of revenue records.
Yes,
You need to have something more than your mere ipsy dixit.
No,
Nothing, no documents whatsoever to
Lords,
prove your
look at the documents that I filed, my lords.
What did you find?
Kindly see, my lords. Look at the exhibits that I filed along with my EA, my lords. The printed detail
Some
of the
registered holders,
the
they
recent
don't know what that is.
The
Who is examined to prove that?
Lord, the MRO is examined, my lords. He himself is admitting that it is my land. The MRO says, yes, they are the ancestral property of this Pata land, and we have acquired a portion of it, remained with them.
And none of those documents are referred to here.
If your lordship sees my...
You don't produce any of these documents along with the...
Where, my lord?
Where do you refer to these documents here? In the plain.
This
is hardly 2 pages.
Plain
claim injunction to rectify.
Yes, my lord, but it has the resettlement register, the revenue map.
Where is the mention of it though?
The exhibits are mentioned there. May I show the trial court judgment, my lord, where it is referred to?
You just list of documents is one thing. Where is the plain pleading?
Nothing in it.
There has to be an averment in the plaint, is it not, to support the evidence?
Can you plead evidence?
The fact which the defendants themselves are admitting, my lords, it's not about me, my lords. Even they are saying it is in the revenue record, it is their own land. If, my lords, when they are saying 5 acres is my own land, my lords, where is the question of me again admitting it, my lords? If the
challenge in this appeal is to the judgment dated 7/11/2022 passed by the High Court of Andhra Pradesh at Amravati in second appeal number 1186 of 2011, confirming the first appellate court judgment of the learned judgment dated 5/3/2010 of the learned 7 Roman 7 additional district and sessions judge within brackets fast track court, Vijayawada, in AS number 87 of 2009. Thereby, the first appellate court confirmed the decree granted by the learned first additional senior civil judge Vijayawada in OS number 851 of 2002. What is the date of the trial court decree?
My lords, the decree, my lords, is 15/3/2004, my lords.
15/3/2004. We find that the very substratum of this entire litigation, namely the suit on which it is founded to be defective in its very foundation, in its very inception. The said suit was filed by the respondent herein. Which respondent?
My lords,
the deceased respondent, my lords. Respondent number 5 who is deceased, my lords.
Respondent number 5 here.
Deceased.
Why is he shown as respondent number 5 if he was the sole plaintiff?
my lords, these are
And the state government and the government deleted him, my lords, from the array of parties.
my lords may have page 33. The LRs are 1 to 4.
One Koganti Jagannath Rao, whose LRs are 1 to 5.
No, but some Muslims have come in. I don't know what is happening. Who are these R1 to 4?
Lords, I am R3, lords, they are subsequent purchases of a portion of the land, my lords.
Was filed by respondent number 5.
Deceased respondent.
Deceased respondent number 5 herein. Koganti Jagannath Rao seeking a mandatory injunction for rectification of the wrong classification of the suit scheduled land in the revenue records by changing it into Patta land by showing it as Patta land instead of government quorum book. We find.
No, not government for a book, it's shown as road approach, minutes.
You don't know what, your prayer also is neither here nor there.
It's shown as road approach.
As patta land. Showing it as plaintiff's patta land. Showing it as the plaintiff's patta land. In effect, the plaintiff, the deceased plaintiff seems to have wanted the declaration of his title, but skillfully molded it as a suit for a mere injunction and paid court fee accordingly. However, the trial court, where is that decree? The judgment of the trial court?
It starts at page 82, my lords.
The last portion.
My lords, the order is
the trial court,
93.
surprisingly, did not even bother to frame relevant issues and merely frame two issues, that is, one, whether the plaintiff is entitled for mandatory injunction as prayed for, question mark, and two, to what relief. Having stated so, the trial court then went on to give a declaration of the deceased plaintiff's title by holding that the plaintiff was the absolute owner of the suit schedule property and that he had gotten right, title, and interest over the suit schedule property. The declaration ought not to have been granted to the deceased plaintiff in a suit of having lost sight of this fundamental aspect. The first appellate court and the second appellate court deemed it appropriate to confirm the said judgment and decree. We are of the opinion that as the very judgment and decree of the trial court are unsustainable on fact and in law, the superstructure built thereon must necessarily collapse. The appeal is accordingly allowed, setting aside the judgments, all three judgments. The suit shall stand dismissed. Dismissal of the suit shall, however, not preclude the respondents who seem to be claimants under the deceased plaintiff to seek appropriate relief if they so choose before the proper forum in accordance with law.
May I also record my statement that the defendants in their written statement admitted my title.
We don't need to go to.
May I mention item 113? Your Lordship, as far back as in October, Your Lordship had said that the suspension be heard.
It will be there tomorrow also.
Yes, Your Lordship.
Today.
I'm the only person, Your Lordship, and conspirators who still
We've already heard you on this aspect.
Item 31, my lords, the Baisakhi matter, my lords, the content has been issued, my lords. My lords, we're just seeking some time, my lords. Counter has been filed yesterday, my lords. Other parties are here also.
Very well. Item 31, learned county for the petitioner.
For the petitioner.
Seeks time to file a rejoinder.
Rejoinder, my lords, 3 weeks.
File a rejoinder.
My lord,
the counter affidavit filed by
the state and the commission.
Filed by the state and the West Bengal. What is that? School Service Commission.
Yes, yes.
School Service.
Lordship, may I mention item 31 and 32?
List on 31 and 32. Both will go to
yes. 31.
List on. How much time do you want?
Those 3 weeks.
25th March.
Lordship, may I mention item number 35?
32 notice has to be issued.
Notice was issued on the last date.
Notice has already been issued.
Lordship, may I mention item number 35?
What date did I give?
25th
March.
Lordship, may I mention item number 35? This year,
you wait till the matter is called, please.
So,
What a glorious ride. The legacy lives on. Yamaha XSR. Build your own way.
Matlab delineates the residential, commercial, the industrial.
It was for the petitioner to have.
Entertainment, everything is segregated.
Okay.
Two weeks. And stay after.
May I just show Lordship in the same SLP that Lordship has, the NOC which was granted by the DM has certain observations in this respect.
Refer to the zoning also?
Lordship will just see.
Which page is it?
Lordship, it is at page 123 of 8042. Mr. Giri's SLP.
23.
123, and I am drawing my Lord's attention to 129.
Yes.
This is the description of the land. They give the boundaries.
To here. Residential units are.
Measuring so and so is situated around 25 more meters. There are no trees. West residential building and land belonging to so and so. North so and so. Then Lordship, the paragraph below that starting Shri so and so.
That's my reference.
Submitted a complaint.
5 lines down. Letter was addressed to Sub-District Officer Sadr Dehradun for conducting investigation on the above request, where the investigation report was received by Sub-District Officer from Tehsildar Dehradun that according to the report of Tehsildar Dehradun dated so and so, residential population and buildings are located as well as local outlets are existing within the 30-meter circumference, and therefore it is not appropriate to grant permission for setting up petrol.
These books are both residential as well as commercial. So we do not know what, according to the zoning regulations, this is.
That is again
zoning regulations are followed normally in breach. That doesn't mean that we just brush aside those zoning regulations. If an area is designated as a residential area, it continues to be a residential area even if shops open.
Just one more document of the MDDA itself at page 112 of the same paper book.
We are not concerned here with the existence of a residential.
Lordship, please, here it's better worded, Lordship.
112.
112 is this letter of the MDDA dated 10th August 2020.
Yes.
The second paragraph, in this regard, it is to inform that Khasra number 1560 is situated in village so and so, on comparing the distance shown in key plan, with the distance in Dehradun Mahayojana 2015 amended. 25-meter wide Mahayojana road is existing in the south of the spot in question. Remaining land beyond the extended road is shown as residential.
Get that? Shown as residential and notifying it as residential is different.
Transfer numbers on comparing distance, 24 meters wide Mahayojana road is existing. Remaining land beyond the extended road. So we don't know what the distance is here.
The 24 meters is the road, Lordship. So basically 30, within 30 because up beyond the description of the road.
Is that shown in the context of the zoning regulation or
beyond 24? So there's a road separating.
Master plan.
Actually, part of 1560 being on the road, the roadside area was
just produce the plan, please. The master plan of this Khasra number 1560, that particular plan you show us. Don't get us voluminous material there. One plan in relation to this Khasra number. This Khasra number. Council for the, what is that? MMDA.
Madhuri Dehradun Development Authority.
MDDA.
Masuri Dehradun Development Authority. And Council for the answer takes time to produce the zoning master plan in relation to the land in Khasra number 1560, and more particularly the nature and usage of the settlement.
But item 101.2 and 0.3, the similar case may arise. That is arising out of a petrol pump in Haridwar. Lordship consider directing CPCP or the authorities to produce the map in that as well.
Haridwar is perhaps available already. You have a plan or something?
Filed it, Manoj, we have filed it with one copy, which is, no, we haven't filed it.
What they filed will not be that.
We filed it, but we need to file an elongated copy because we know, but for your lordship's convenience.
You have a bigger
Yes,
plan?
yes, Manoj, we'll get a bigger plan.
Right.
Your lordship may leave it on us, Manoj, we'll get it.
Similar master plans will also be filed in relation to the land in 101.2
and 12.3.
You're also appearing in this?
My lord, yes. According to us, it's unambiguous, but we'll place the plan.
Manoj, can we have it on next Thursday?
He wants 2 weeks.
2 weeks, very good.
18th Feb.
2 weeks. Manoj, there's 101, will it come, will it be shown as 101 only?
Matter will retain its position. Because it's a partner, it will come on.
Yeah, one of my friend wants to request for his appearance to be put on call because some of they are not taking. Great, most great. Most great.
Physical appearance.
Grateful, Lord.
Please also.
My lords.
Yeah.
Before my lords start, my lords, I am appearing 101.2, my lords. I have moved an discharge application. It's showing in the office report also, my lords. We tried to contact the clients from last 2-3 years. So my lords may discharge me from the.
You are appearing for whom?
For Govardhan.
রূপসীমা বাংলা আমার কাঁদবে না গো পাল্টানো দরকার চাই বিজেপি সরকার
I glide through the blocks like the breeze of July. Sunglasses on, got the glimmering eye. Cap waves, rooftop days, I know every way.
This is
First, I'll give you my. Oh, you write down the cost.
this. It's it.
102.1.
Oh, 102.3.
102, my lords, I have already filed my written submission also. But 102.1, there is a discharge application pending for a very long time. But I am ready with my arguments.
This practice here of discharging counsel, it's beyond my comprehension. Once you enter appearance, you file a wakalat, you can't just say I'm turning my back on my client.
My lords, from last 3 years we have been trying.
Have you sent any registered notice with acknowledgement?
Yes, my lords, we
You
have
did.
written.
Then you report no instructions. We won't discharge you. We'll dismiss it on the ground that
Please, my lords, please, my lords.
because there's no point in discharging you and then making the registry run around trying to serve that person.
My lord, but we tried.
What do we do?
I
Learn counsel for the appellant, Govardhan Singh Devanya, states that despite her post with acknowledgement due, she could not contact the appellant. A discharge application has been filed by the learned counsel on these grounds. We are of the opinion that in the event the appellant fails to show interest in pursuing his matter, he would not be entitled to seek further indulgence. The appeal is accordingly dismissed for non-prosecution. Yes, 102.
102, my lords, please. I appeal for the appellant.
Yes. Exemption from surrendering ground.
Yes, I was granted when the notice
Felling
was-
of trees.
There is a short written submission, my lords, will find. In fact,
Trees on your own land.
Yes, my lords.
These trees were
Yes,
held
these
on
trees
your
on
own
my
land.
own land. In fact, my lords,
You need to take permission for it.
yes, if I will, my lords, if I will take my lords only through the written submission, without even opening the file, whenever my lord will require, I'll show the pages also.
Yeah.
But we can just go by the written submissions, my lords. Because certain dates are also very relevant. Dates and the status of the parties.
The Tehsildar and the collector are let off.
Yes, now there are two lands.
You are,
I am Hastimal
you are the owner.
I am the owner, I am the purchaser.
You are the purchaser of the land.
Yes, the vendors are not vendors of both the lands. They were never made the accused.
No, but who cut the tree?
No, the allegation is not just cutting the tree. The allegation is a little bit different. The allegation is that I'll just take my lord to the list of dates. But my lord may just see.
The other man is the Patwari. 102.1.
Govardhan is Patwari. Patwari. He is the Patwari. My Lord, may just have my written submissions. My Lord, may just have para 2 for a moment so that I just make the status of the parties clear.
Yeah.
And just before that, my Lords may just take into account that there are two lands which are in question, both were purchased by me. One is the land in village Balu, which I call as L1. And the other is a land, Khatra number 265 by 2, which I call as L2. Now, as far as L1 is concerned, my Lords, I have been acquitted, even I have been acquitted.
These are in two different villages.
Yes, but the...
Partly each other.
Yes, my Lords?
These are in two different villages.
Yes.
Are they adjacent to each other?
Villages are adjacent to each other. They are
These
both...
lands are also
yes,
adjacent.
they are both in the same district.
Right.
The Tehsil is also same. Tehsil is Dantewada.
But two different villages.
Yes. There are two lands. The context is that, my Lords, as far as the first land is concerned, the Khasra number 1183, even I have been acquitted by the High Court. High Court has set aside the conviction of all the accused with regard to the first land. With regard to the second land, two accused have been acquitted and two have been convicted. I am one of the accused and the other accused is my Lord 102. So, my Lord, may just have para 5, the list of dates. Now, I purchased these lands, my Lord, both the lands, in January 1991 and February 1991. The first land was purchased by the owner, the vendor.
What is this? It's the written submission. What is the written synopsis? Written synopsis. Okay.
Yes, sir. Yes.
Yes.
Yes, please. Now, the date of purchase by me,
11 January.
yes, 11 January and 4th of February 1992. I purchased from different vendors the respective landowners. Now, as far as the sale deeds are concerned, those sale deeds are annexed in the additional documents. Both the sale deeds, I am represented that these vendors, they were absolute owner of the suit property. There is absolutely no encumbrance on the suit property. When I purchased the land, there are trees standing on the land. So they also give the consent letter to me that you can cut down the trees. We have received so and so consideration. Now, when I also purchased the land, at that point of time, all the revenue records were mutated in their favor, in favor of the vendors. Both the vendors, they were shown as the Bhumi Swami of the land. There is no dispute. There is not a single document produced by the prosecution showing that even revenue records actually showed that the land was a patta land.
Right.
Now, after I purchased my land, I wanted to cut down the trees. I had taken the loan for purchase of the land. So to repay the loan, I wanted to cut down the trees, for which there is a permission under the Land Revenue Code. Section 241 of the Land Revenue Code says that if you want to cut down the trees, you have to take permission from the collector. So the process is that I file an application, but while he goes, he inspects the properties, he submits a report to the Tehsildar, and NOC is to be taken from the Forest Department, because a lot of area in the Dantewada district is a forest area, and then the collector ultimately grants the permission. So I follow the entire procedure. There is NOC from the Forest Department. Admittedly, it is not even a forest land. Admittedly, these two persons were not tribals. Earlier, their contention was that they are tribals, but ultimately it came in the evidence that they don't belong to even tribal category. So I take the permission, my lords, on 4th of June 1994. That is there at Annexure A10 of the additional documents. And then I cut down the trees. I sell it only to the Forest Department. I don't sell it to any private party. So government only purchases those trees from me. And I receive a consideration of rupees 4.66 lakhs from the government. Now, my lords, in the year 1998, in that Godavaraman case, my lords were actually considering, the issue was entirely different. My lords were actually considering the sale of land of the tribals to non-tribals by fraudulent means, or cutting down of the trees in forest areas. Private land and all these lands, my lords, were in fact not even the subject matter of those proceedings. But in that proceedings, there is an order passed by the Honorable Supreme Court, where it is said that CBI should investigate where the foreign forest lands, the trees are being cut down, or the lands of the tribal are being sold to the non-tribals. So during investigation, the CBI registers an FIR. I am not an accused in the FIR. So they register an FIR for the period between 1992 to 1996, saying that in collusion with the certain officers, the landowners are actually getting the trees cut down, and there is a violation of provision of some aboriginal law there in the state. Ultimately, there is a charge sheet filed. So when the charge sheet is filed, all those persons who were made the accused in the FIR, they are not arraigned. They investigate and then they make me as the accused person. along with 3 officers. Now the allegation is that we could not have actually purchased these lands because sometime in the year 1984, these lands were actually settled in the name of these vendors. So these vendors could not have actually absolutely alienated or sold the land to the purchaser or to any other private person. Now, please also take it, my lords, from me that there is no single document, no single exhibit produced by the prosecution in the entire trial showing that there is actually an order. That order of grant or settlement is not produced. So there is a provision under the Land Revenue Code, section 165(7)(b). It says if the land has been granted by the government to a particular person, basically the patta lands, my lords, in a layman's language. So if it is a grant, then you actually can't sell it to any private person without taking permission from the collector. But in the entire prosecution case, in the entire trial proceedings, in respect of both the lands, there is no actual order of grant produced. So if there is no actual order of the grant produced, I cannot.
What is this permission of additional collector you refer to in page 2?
Yes.
For cutting the trees.
Those are, my lords, for cutting the trees.
Cutting the trees.
So there are 2 kinds of permission.
Okay.
One is cutting of the trees, that I have taken the permission. There is no dispute. But then initially they tried to make out a case that I have illegally cut down those trees. Subsequently, in the charge sheet, the case became completely different. They say that I have purchased the land illegally from the vendors. Completely different case. So they say that there is a violation of section 165(7)(b), which says that if the land is by government grant. But on record, my lords, there is no exhibit producing that government grant with respect to both the lands. Ideally, it is in the form of a lease document or a patta document. So they rely on certain registers, past registers, where that land is recorded somewhere as a patta land, settled in the name of, they use the word settlement, that these lands are settled in the name of vendors. Therefore, they assume that it is a patta land. Now, I'll show from the trial court records also, these lands were actually recorded in the name of these vendors from the year 1960s and 1970s. Now, my lord may just have para 6 now. There are 14 witnesses, but only 4 prosecution witnesses are relevant. Most of them, my lord, they concerned with the sanctions and the various procedural aspects as to who signed the Patwari report and then who signed the Tehsildar. But as far as I am concerned, my lord, these 4 witnesses are relevant. Paragraph 6b, my lords, PW1, he is the deputy collector. He says that according to me, they should have taken permission because the land was settled. Then when he is asked in the cross-examination, he says that the CBI has not shown me any document of patta or grant. Then there is PW4, Ramcharan Goti, who was deputy collector. And he says that in the file, there is no actual document of patta, no actual grant. Then PW13, my lord, is one of the inspectors of the CBI. He says that it is correct that at the time of recording of statement of Chandan Singh and Dhananjay Singh, they told me that they are covered in non-Adivasi backward class. It is correct that they had told that their land is ancestral land. Then again, my lords,
what does that mean?
Yes, my lords.
What does that mean?
That they are not Adivasis. So that only this tribal lands cannot be.
That they are covered in non-Adivasi backward.
Yes, I'll show from the, my lord's, trial court judgment also.
They had
but for the purposes, my lords, only of the evidence, please also note the evidence of PW14.
Yes.
Lords, where the IU is also not able to show the exact document from the records. Where is that actual patta? And he also says that even though they have actually sold it, I have not made them accused. And then I produced, my lords, my witnesses, basically the relatives of the vendors. They say that these lands are my ancestral, were our ancestral.
Then
yes. Then my lords may just have para 7. I have summarized the relevant portion of the trial court judgment. Till page 77, my lords, the issue is with regard to the validity of the sanction and all those things. I am not concerned with the sanction. Now, what the trial court does, my lords, the trial court actually starts deciding the case like a revenue case. It says that I will decide the nature of the land. What is the nature of the land? Whether it is of the ownership of these vendors or these were government lands.
So it decides that this is not Malik Makbuja.
Yes, so Malik Makbuja basically is of absolute ownership. Even Marhan land, my lords, there is no law which says that Marhan land is actually a government land. Marhan land is like a village land. So, but there is absolutely no provision anywhere in the entire Gujarat of the Madhya Pradesh Land Revenue Code saying that Marhan land is a government land or anything. But my lord may just have page 89 and 90 for a moment of the SLP paper book.
Yes. 89.
Page 89. Only the relevant part, my lord, I'm showing, because otherwise the trial court has basically tried to interpret what the land revenue code means and the other circulars and all those things. Paragraph 43 onwards. If I may just read, my lords. In exhibit PA1, in bracket E, no, exhibit PA1 is actually, these are the mutation records. The land of Khasra number 265 in dispute of this case has been referred as the land of Amma Marhan and its area has been mentioned so and so. In this document, it has been mentioned that the land is the land of Marhan category. Therefore, on perusal of this document, it reveals that earlier in the year 1964-65, the land located in village Chitalur so and so, some Amma Marhan was marked with land of Khasra number 265. In accordance to entry prior to year 1955, the land of this Khasra number, exhibit so and so, was considered as the land of Chandan. I'm only trying to show that as a purchaser, my lords, all I could have actually seen were the documents which were available in the public domain. The revenue records, the sale deed was considered as the land of Chandan. This Chandan is my vendor. So even in the year 1945, he was recorded as the owner. But entry of this document made at serial number 6 and 7 has been crossed with reading, but any reason for doing this has not been mentioned in the record. However, it is proved with this record that Amma Marhan land situated in village Chitalur later on had become the land of Khasra number 265. But on marking name of Chandan with reading in record of exhibit A1E, it cannot be considered that in the year 1965-60 or prior to it, this land was ancestral land of Chandan. 45 says the document exhibit A1F is Kishtbandi Khatoni of 1986-1987, land ownership of Chandan, son of Sade, which is situated in village Chitalur. Document by way of registered sale deed, Chandan has been referred as the owner with land. Yes, sir. Till page 92, the trial court says that the revenue records actually showed Chandan as the owner or a Bhumi Swami basically in the revenue records.
Now you are convicted under 468 acts.
Yes, so I have been convicted, my lords. I have not been convicted under PC Act by any means, even a conspiracy. I have been convicted under section 120B read with section 420, 468 and 461. Now, as far as forgery is concerned, they don't, my lords, explain as to what is the forgery. It is not a case as if I have signed any document or the person who has actually signed those reports has not signed. For forgery, it is necessary, my lords. Even inviting section 468 prima facie, you have to actually make.
Mr. Rajkumar, anything? What is there in this?
No, first of all, those two vendors, they have not argued to it if it is a case of conspiracy. No.
There's not all that. Against him, what do you have?
No, it appears for us as we go as the buyer beware, if your lordship is.
But you don't even have a document to show that this is a assigned land.
I'll point out from the evidence of the witness.
He's read out what they said in cross-examination. He says that the CBI did not show me any document, one witness. The other one says, I have no idea whether this is assigned land.
And you go by a red cut mark. No authentication, nothing. The records clearly show that somebody cut it off. From 1955, it is with Chandan.
So far as that permission for cutting the tree has got permission, that is not.
No, you don't produce anything to show that he should take permission for purchase also.
And what
only one fact still late.
देहात की तरक्की की सिमत अब देहात खुद तय करेंगे। तरक्की याफ्ता ग्राम पंचायत प्लान्स के जरिए मंसूबों को पीएम गति शक्ति से मजबूत किया जाएगा। वजीर आजम नरेंद्र मोदी जी की क़यादत में इस कोऑपरेटिव तरक्की मॉडल की बुनियाद रखी है तरक्की याफ्ता भारत।
Case number is the only evidence, so far as
Some register.
Yes.
That's all. No document.
That
nothing.
is-
And that to what? 1945 Chandan Singh is there.
55.
45.
55.
55 or 40?
55.
55.
And Chandan, that name has been
The settled by the government.
No authentication.
Because they were the.
And even according to that code, it's not as if it's completely barred.
There is a time period.
You have to take permission from the collector. So it's a curable defect, if at best.
And not only that, only unless it is a notified area of tribals, you need to get a permission only within 10 years or something.
For that, there is a separate provision in the same 160.
This is not even tribal.
This is not
It's not tribal.
private land.
So the sale deed also, if your lordship will please to see this.
They claim to be owners. If we are the
Prior title, nothing is mentioned now.
They need not prove it. You registered the prosecution. You have to establish it. You can't ask them to prove that Chandan had it from 1900.
It is a case of the prosecution that it's a conspiracy, my lord, by virtue of which the settled land was purchased, my lord. And then thereafter, my lord, the patwari that is going.
See, for that you have to primarily establish that it is a settled land, for which there is no document.
No, the settled land is only, my lord, the that case, land allotment case. That's the.
Nothing, no document produced.
That is the. We have produced the settlement register exhibit P5.
Appeal number 3398 of 2020. By judgment dated 3/7/2013, passed in special criminal case within bracket CBI number 51 of 2004, comma, the learned special judge within bracket CBI, comma, Raipur, Chhattisgarh, convicted the appellant under sections 420, 468 and 471 of the Indian Penal Code, read with section 120, capital B of the Indian Penal Code. 120 thereof. He was sentenced to a maximum of 3 years of rigorous imprisonment in connection with his conviction, understated with fines in relation to each of the offences, coupled with default sentences also.
Yes.
Default sentence. How long were you in prison?
No. I was always on bail.
Always on bail. The conviction and sentencing of the appellant stood confirmed by the High Court in criminal appeal number 679 of 2013, when the division bench of the Chhattisgarh High Court dismissed the same with a judgment dated 29/7/2019. The allegation against the appellant was with regard to his purchase of 2 extents of land under sale deeds dated, registered sale deeds dated 11/1/1991 and 4/2/1991 from one Tirpal and one Chandan Singh. These lands were situated in which villages?
In village Balud and Chittalur.
Village at the top you mentioned, Balud, B-A-L-U-D, and village Chhitalur, comma, both situated in both Tehsil Dantewada, District Bastar, Madhya Pradesh, at that point.
Now Chhattisgarh.
Within brackets, at that point of time. According to the prosecution, these lands were not alienable by the vendors on the ground that, which provision of the Land Revenue Code you said?
Section 165.
You extracted it.
Yes, ma'am. Page 3 I have extracted.
Were not alienable by the vendors in the light of section 165 within brackets 7-b of the Land Revenue Code,
Yes, ma'am.
Madhya Pradesh Land Revenue Code, comma, 1959. However, we find that there was no absolute bar posited by the said provision, and it merely required that requisite permission, required that permission be taken from the collector prior to permission be taken from a revenue officer not below the rank of a collector for prior to such alienation. On facts, we find that the aforestated provision did not even stand attractive in the case on hand, as no clinching evidence was produced by the prosecution in proof of the subject lands having been allotted or granted by the state government or the collector subject to conditions. The witnesses produced by the prosecution also failed to substantiate this aspect of the matter. In the absence of this foundational fact, the trial court was in error in convicting the appellant on mere surmises and conjectures. The High Court also fell into error in confirming the said judgment of conviction and sentence. The appeal is accordingly allowed. Mention one fact I forgot to mention. Exemption from surrendering was granted by this court on 30th September 2019. 30th September 2019. The appeal is accordingly allowed. Setting aside both judgments.
Lodge.
103.
Oh, it should not be. Yes, Mr. Lokesh.
Mr. Ballal. Yes, on behalf of the municipal corporation.
5 minutes. You can lay the foundation and continue.
Yes, briefly. The dispute in this case is whether this land vested in the Gram Panchayat or in the.
Just turn this around so that you can speak in.
Sorry.
Is that on? One is showing up red, the other is not. Both are on?
These are on, but I do.
It doesn't take the weight of two lawyers.
It seems to be on. Yes.
But I'll try to be as loud as possible.
Yes.
The dispute is basically I would represent the Gram Panchayat, which has now been taken over by the municipal corporation, Gurgaon. This land is in district Gurgaon. The dispute.
But the appellants are individuals, isn't it?
Yes, Lord.
One appeal is by the individual who is resident of the village.
4 appeals.
There are 4 appeals. The rest are all municipal corporation. But where is the council in the first matter then?
I'm there.
You're there. You're conceding your advantage to the municipal corporation? Yeah? All right. Well, he's conceding.
Yes, he is resident of the village. His interests are same.
Oh, I see. You are all sailing together.
Yes, yes.
Oh, I thought he would be.
No, his interest is same.
But there'll be some documents which we'll refer to from his petition.
No, as long as you're sailing together, then there's no difficulty. Yes. I thought he would be opposed to you. You are opposing.
Yes, my lord. The preliminary issue will be the locus, my lords. About the individual, because these proceedings arise out of a statutory declaration that we sought, that the revenue entries of 54 were contrary to the previous records. And except the revenue record, the claim of the Gram Panchayat, which is subsequently represented by the Gurgaon municipality, has no legs to stand. The individual in his individual capacity is not in a position to maintain these proceedings.
I think
Gram Panchayat.
I think it's my turn, I think.
Yeah, no, I'm just giving an overview.
Before you chop my legs and arms and everything.
He is indicating to you what hurdles you will have to
I thought he would keep his gunpowder dry.
No, this is the only point. Lordships have read the files earlier.
We have not read the file. Final hearings, I don't read.
Oh, I'm sorry. Last time we had indicated that.
You never know when you take an adjournment. What is the point of going through something like this and then you'll come up with an excuse and say, I don't feel like arguing today, I'm going to lower the garden.
This is the typical Haryana, Punjab litigation where a lordship will have to go through a large number of those Jamabandis, then revenue records, wajibulars, etc., etc.
Land in Gurgaon, obviously.
Yes,
Yes.
land is.
It's a
Common Lands Act in
Yes.
Gurgaon.
It's
That's
something
right.
akin to what you should have read between Hyderabad and Andhra.
is
Malot.
a builder.
No,
No, I'm not. Listen, he was trying to chop my legs. I'm trying to do the same thing.
Respondent is not the builder is behind the respondent.
He's there, my lord.
Take it somewhere in the background.
Fortunately,
Gurgaon, obviously there'll be a builder working at the background.
is not a activity, my lord, which is prohibited.
no, nobody is saying it's prohibited.
So you don't paint them like this.
I'm only using the same paint he used. That's all.
I was on locus. Builders have locus. There's a difference.
Absolute locus, Lord. Builders build the country.
All right, so we'll let you off today, so you can start tomorrow.
Yes.
List tomorrow is the first item in the regular hearing matters.
104 million. In that application for premature is pending million, the state million.
Actually, it will take 3 months to.
What do you want?
Matter may be listed after.
You want an adjournment?
Yes, sir.
Already released on bail.
Premature release is pending, your lordship.
26th is also over.
Already is on bail million.
26th January is also over. You're going to wait till August now.
Lordship. No, lordship, actually.
This generosity only flows at Republic Day or Independence Day, is it not?
No, lordship, it is
Then-
for the company that your lordship. Anyway, is on bail.
But you let Republic Day also pass. How many people did you release on Republic Day?
I don't have that illustration.
Why was he not considered for that? How much time do you want?
3 months.
3 months.
I mean bail million, I am not.
Why is he? You're all by day. The Council for the State of Tamil Nadu states that the process of considering don't say process of the consideration of the petitioner's case, appellant's case for grant of premature release is still ongoing and seeks time on that ground. Based on 3 months you want. You take it up after the list on 22nd July.
Public.